I'm Joe Considine. I'm from West Palm Beach, Florida. I'm an attorney. I practice marital and family law, which includes assisting families through the Marchman Act in getting their loved ones into treatment using this civil process, not a criminal process. And the process is basically a two-step, involves two steps. One is having the person assessed and stabilized, which I sometimes just refer to as the detox part of the process. But it's during that period of time where the facility can keep them for up to 5 days and have them be assessed by a licensed provider. The assessment report then comes out, and if it indeed recommends treatment, then the second step takes place, which is where we file the petition for involuntary treatment. And at that point in time, with the assessment report, the family, any relevant witnesses, the treatment professional, we all go into court and we show to the court, in South Florida, it's a magistrate. Up in Central Florida, North Florida, where you don't have magistrates, they involve the judges themselves. But we show the court that why the person is substance abuse impaired and why they don't appreciate their need to get treatment, or that they've inflicted harm on themselves or they're about to inflict harm on themselves or others. The first phase of the assessment phase is an easier evidentiary standard to meet. It's just by a showing of a mere preponderance of evidence that a good faith reason exists that this person needs to be assessed. Again, that the criteria being that they have a substance abuse impairment, and that one of two other things happen. That because of their impairment, they don't realize that they need treatment, or that they've inflicted harm on themselves, or they're about to inflict harm on themselves. The second phase is a more difficult phase. It's the burden of proof of the evidence is to show by clear and convincing evidence, which is much more difficult. If we looked at, if my hands were the scales of justice, the mere preponderance means that you just have a little bit more evidence in favor of your proposition than not. Clear and convincing means that you have a lot more evidence in favor of your position. So that's basically what we do. We find that there's studies. There's a study done by UCLA. There's a study done by the National Institute of Mental Health that shows that people who face court sanctions, if they don't complete treatment, tend to do better. I was surprised when I first did the research on that and found that to be the case, and I can be contacted and I'll be happy to provide the sites for that. But they tend to do better. You know, there's kind of a fallacy, I think, in the recovery community, and I do a lot of my practice. I also involve divorce work and so forth, and I represent a lot of people, not only in the therapeutic community, but in the recovery community, and they think that that people don't get help or won't recover unless they want to, and ultimately that's true, but we can help them want to by the use of court-ordered sanctions. I had a case involving a very wealthy woman, and she hired a lawyer out of Miami, and that lawyer told me to my face that everybody has a right to drink themselves to death. And I said, not in Florida, they don't, because of the Marchman Act. And interestingly enough, there's only 2 states in the union that have anything like the Marchman Act: Florida and Kentucky. Go figure, Kentucky. And interestingly enough, that finally somebody can say something progressive about the state of Florida, where we have the legislature knew what they were doing when they were doing this. It works. I see that it works in my practice. There's a misnomer sometimes, even among treatment and the therapeutic community, about the Baker Act and the Marchman Act. The Baker Act is for mental health issues only, and it's where the person is a danger to themselves. It's a different standard than the Marchman Act. Marchman Act is only for substance abuse. There may be a co-occurring disorders, and I heard you guys talking about that, so I can repeat that phrase. I'm not sure I know what it means, but I think what it means is that there's a mental health issue going along with the substance abuse issue. And I think most people with substance abuse issues probably have some mental health issue of some sort or another. So there's some interplay, even though they're different. Obviously, the Baker Act will apply for people who have no substance abuse issues but who are a danger to themselves. 49% of Baker Act proceedings are filed by practitioners. Another 49% are filed by police. Only 2% by private individuals. Marchman Act is much more kind of user-friendly for families. And obviously it involves substance abuse. As we were talking before, sometimes there's an interplay. I had a case yesterday that we filed. The psychiatrist tried to get the woman Baker Acted, but she really wasn't a danger, an absolute danger to herself or an imminent danger to herself, but she definitely had substance abuse issues going on. We were able to, on an emergency basis, get a pickup order entered for her to be assessed, which is the first step of the process. I'm available for consultation. My name is Joe Considine. I'm in West Palm Beach, Florida. I really enjoy being able to help families through this legislative statute. It's not a criminal statute, it's a civil statute. The way that it works is that if the person who's been court-ordered to treatment leaves or doesn't show up, I'm able to bring that person back into court, and the judge will then basically ask the person, what is it about my order for you to be in treatment that you did not understand? And then gives them the option of either being a guest of the county in a county jail, or to go back into treatment and do what they're supposed to do. Most people who haven't had a lot of experiences with incarceration don't want anything to do with it. For people who have been incarcerated, they don't care, you know. But I find, especially among the young who haven't been incarcerated, they don't want to go to jail. They'll go back to treatment. So again, it's not a criminal statute. It's a civil statute that allows the court this leverage of contempt and ultimately incarceration, but only to enforce compliance with the court order, not as a punishment. It's to enforce compliance. So anyway, thanks for the opportunity to be able to present here. I did it last year, and I enjoyed it this year, and I hope to be invited back. Thanks so much.